Hello, hello. Welcome to Crime in Court. My name is Heather, and I have a lot of information again for you about the Canton Cover-Up case. This is episode 9, and we're going to be talking about Officer John O'Keefe's injuries. So, I just want to give you a graphic warning. Whoops. There we go. So we're going to be going over John's actual autopsy photos. So this is a trigger warning to anybody who is squeamish, doesn't like to see blood, doesn't like to see certain things when it comes to pain and whatnot. So this is up to you at your own discretion if you want to look away. I don't mind. We're going to be talking about graphic things throughout, on and off throughout the episode. However, this is probably the one and only time that I'm going to be showing the photo. And if I go to show it again, I'll probably do another graphic warning. So, with that being said, I'm going to switch over to the next slide and we're going to look at John O'Keefe's injuries. Bear in mind that the Commonwealth is claiming that he was hit by a car. Okay. I did show his arm in another episode, so I'm curious to see what you guys think. You guys tell me what you see when you look at these. If you are brave enough, I mean, it's not bravery, but it's like curiosity, I guess. In my mind, it's curiosity to know and to learn and to find the truth. So, without further ado, I'm going to switch to the next slide, and if you don't want to see it, please turn away. All right, so we know that there were no injuries below his head and neck, except for his arms. So I don't know how that is a car accident backing up to him, into him, but I don't know what the Commonwealth is trying to say with their theory. But John's injuries were more consistent with a beating rather than a low impact vehicle collision. So as you can see, I'm going to hide myself here so you can see his hands. You can see his knuckles are all black and blue. You can see my mouse circling around that, the bottom picture in the middle. It's you can see those are his knuckles. Doesn't that look like someone that was potentially in a fight? Fighting someone? And both of his eyes are black and blue. His face is all banged up. I mean, I know it's very graphic and awful to look at, and I'm sorry if you aren't one of the people that, can take it. I know there's a lot of people that cannot. I personally, on the other hand, I look at it as a learning experience. Because we need to learn how John passed in order to find out if Karen Reed should be receiving charges to go to prison for probably the rest of her life, or the majority of. Anyways, let's take a closer look. So this is like just another angle of his knuckle there. You can still see that it's bruised, and then up at the top you can see his arms, and we're going to go look at those in closer detail. You can see the Commonwealth, and we'll get into some of the arguments here, but the Commonwealth is trying to say that these are abrasions when they are actually lacerations. They should be classified as lacerations. So here is a closer image of his that's his right arm, and you can see he's got these like marks that are going down his arm, but then they get like smaller here and kind of jagged here. Well, a really great resource, and I've mentioned her before, is attorney Melanie Little. She's also going through the documents in this case and talking about certain things that are going on. She's staying up to date with what's happening now once she started covering it. And she's doing an excellent job I love watching her. But she had an expert on recently. Garrett, I can't remember his full name, but he was a dog expert, a canine expert. He's been around canines his whole life. He trains them. He trains them specifically to bite people. So like police dogs to bite the dogs attack dogs to bite when they are trying to run down and catch a perp. So that is the training that this guy did. And he came on the show, on Melanie Little's show. They did a show together, like he was a guest on her show. And here's a picture of that day when he was on the show. And he had a couple examples of what dog bites actually look like. He said, without a doubt, 100%, he would classify what John's injuries, as a dog bite. Whoops. So he said, oftentimes, and if John was wearing a long sleeve shirt, um, the dog would have trouble getting a hold of the skin, which would be why there's so many attempts to try to bite him. Why there's like these little tiny ones and then there's bigger ones. Like the dog is trying to get a grip. So he was bit several times by a dog. Not just once, but it looks like the dog kept trying to get onto his arm. And that expert, I'm going to go back to his picture here. Garrett Wing is his name. And he did an excellent job explaining how dog bites, they usually do have these tears because the dog is coming down and then the arm is pulling up. And then, it leaves these tears that are just going up and down your arm, like you see in John's autopsy photos. So this is 100% a dog bite. On the news, it was just a sample that Garrett had pulled up. So it is very similar, as you can see, in comparison to John's wounds. The only difference is he had been laying there for a very long time, and he had been also excreting DNA, the red wet kind. So at that point, his wounds might have, started to congeal and, plus he was losing that red stuff, the red DNA stuff that I can't say. But yeah, so, take a look at these and tell me if that was someone in a fight or if that was someone who got backed up into by a car. I'm just saying. Use your common sense. Use your common sense to figure out what happened. Okay. They keep lying to us and saying that these are just abrasions. And abrasions are, let me put my camera back on. Abrasions are like a scrape. A little scrape. Or something that doesn't go very deep into the surface of the skin, whereas a laceration does do damage. It's like cutting into the skin, like a dog tooth tearing the skin. That's a laceration. And the Commonwealth of Massachusetts keeps telling us that this is just an abrasion, but to me, in my eyes, in my head, tell me that's a laceration. All right, I think we're probably done looking at photos for now. But if I do reference back to them, I will come back and let you know that I am coming to talk about them again. All right. So first off, we're going to talk about what the Commonwealth says about the dog and the dog bites and everything. So hold on one second. Okay. So the first thing we're going to read this is a document from the Commonwealth. It's a memo in opposition to the defendant's motion pursuant to Rule Criminal, 17. So the production of Canton Animal Control and the clerk's office, Canton clerk's office. So what they're asking for here, what this is in response to the defense, Karen Reed, submitted a motion to produce the records of animal control so that they can find out what happened to Chloe, because we're wondering what happened to Chloe. And his autopsy, well, we'll get into this, but I was just gonna highlight here that they, in this, they're saying that it's just a fishing expedition trying to get the records from the animal control to see what happened with Chloe. They're saying it's just a fishing expedition. Anyways, let me skip to the right page here. All right, so this is kind of a description in the Commonwealth's argument back to as to why the defense should not be able to get the records. Here we go. So following their initial witness interviews on January 29th, troopers Buchanan and Proctor then proceeded to the Good Samaritan to view the victim. Again, this is going to be graphic in description, so I'm just warning you. They observed 6 lacerations that had the red DNA on them, varying in length on his right arm. So we just saw the picture. The cuts extended from his forearm to his bicep, so it's all over his arm. Both of the victim's eyes were swollen shut and black and blue in color, which you could tell from the image that I showed you, unfortunately. The troopers observed a cut to the right eyelid of the victim. The victim's clothing consisting of blue jeans, an orange t-shirt, a long sleeve gray shirt, and boxer shorts were soaking wet and saturated with blood and vomit. The victim was also observed to have one black Nike sneaker with a white Nike logo on the side. So remember, he was found with one shoe. The second shoe was found on the second search of the house, of the scene. It wasn't found until way later. All right, so the victim's medical records were admitted as an exhibit before the grand jury in this matter as well. Throughout said medical records, the attending physician and medical personnel described the victim's injuries at length. Said description of his injuries and medical conditions include a right superior orbital ridge region, approximately 7 millimeter laceration, and surrounding soft tissue swelling, contusion, and breath sounds bilaterally, pulseless. So he didn't have a pulse, but he had some breathing sounds. Superficial abrasions or to the right arm. So they're just calling those wounds superficial, the ones on his arm that I showed you. And the time of his passing was noted at 7:50 a.m., which is almost 2 hours after they found him. Yeah. On January 31st, it is possible they took some time to try to warm him, and because they still had signs of his breathing, it may have taken some time until they were able to actually call the time. Anyways, on January 31st, Dr. Irene Scorti-Bello from the Office of the Chief Medical Examiner conducted the autopsy of Mr. O'Keefe. The doctor advised the troopers that she observed several abrasions. Again, they keep calling them abrasions, and as I explained to you, they should be described as lacerations, but they are not. So they're calling them abrasions to the victim's right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of the nose, and approximately 2-inch laceration to the back of the head, and multiple skull fractures that resulted in the brain. I don't know how else to say that. Leaking red DNA. All right, so Dr. Scorti-Bello further advised the troopers that the victim's pancreas was a dark red color indicating hypothermia, that was a contributing factor to his unaliving. So, the cuts and fractures to his head and the hypothermia are what they believe he succumbed to. Um, so where did I leave off? Dr. Scortibello further advised the troopers that the victim's pancreas was a dark red contributing factor. Okay, so Dr. Scortibello opined from her examination that the significant blunt force trauma injuries occurred prior to Mr. O'Keefe's becoming hypothermic. So she was able to determine that the injuries to his head and his hands and his arms happened before the pancreas became a dark red to indicate hypothermia, as evidenced by hemorrhaging in his pancreas and stomach. So that, I guess, came later, and she was able to tell that way. So Mr. O'Keefe had arrived at the Good Samaritan Medical Center with a body temperature reading in the low 80s. So remember, I went over what hypothermia, if you didn't watch episode 8, the deleted data, go watch that, because I go over the house long to die in cold and what Jen McCabe would have seen or something to that effect had she searched that at 2:27 a.m. as her phone records indicate. She would see all of the different symptoms that John went through in order to go through advanced stages of hypothermia, and I read all of the stages. So she would have read that and known what was happening to John's body out there in the cold. Just saying. So the doctor opined that the extensive injuries to his head likely rendered Mr. O'Keefe incapacitated. The doctor further opined that upon viewing Mr. O'Keefe's injuries and her examination of the body, she observed no signs of Mr. O'Keefe being involved in any type of physical altercation or fight. You guys tell me what you think after having viewed those photos. If you need to, go back. I don't want to show them again if it's going to offend people. So yeah, do you really think that those injuries were... Can you definitively say to me that those injuries were not due to some type of physical altercation or a fight? Even after 2 bloody, swollen eyes, swollen shut, and bruised fists, not to mention dog bites on his arm, and the homeowner owned a German Shepherd, which is now missing or unaccounted for. In addition, Dr. Scortibello testified extensively regarding her examination and findings before this grand jury. So the grand jury minutes are attached for this exhibit. We don't see it. It's probably sealed. As well as Dr. Scortibello's report of the autopsy. So in her testimony, the doctor described the medical definitions of a laceration, a contusion, and an abrasion, as well as the differences between the three. The doctor testified that the victim had abrasions on his right arm. Again, those should be described or determined to be lacerations, not abrasions. She described abrasions as scratches caused by a blunt object, contact with a blunt object. Dog teeth, I don't think you could say are blunt. So she went on to describe them as a cluster of them on his right upper arm and his right forearm, mostly linear and ranging in size from a few millimeters to up to 7 millimeters. Dr. Scortibello testified that throughout her thorough external examination of the victim's body, she observed no signs of an altercation or fight. Okay, again, she's holding true to that one. The doctor also testified extensively to the injuries or swelling of the victim's eyes. Dr. Scortibello testified that from her examination of the victim, both external and internal, that the bleeding and subsequent swelling around his eyes was related to the very small fractures in his skull. So they're saying all the swelling and all the redness and the red DNA stuff, that's from the fractures around and in and on of his skull. Like he's got a 2-inch laceration in the back of his head. That they called it a laceration, and that's probably correct. And then the rest are contusions, bruises, swelling. All right, so she testified specifically that the injury initiated or started in the back of the head, caused all the fractures in the skull, and then the eyes got red or black or purple because of the seepage of the liquid stuff from small vessels that carry that liquid DNA stuff. So the neuropathology report completed by Dr. Renee Stonebridge, also of the Office of the Chief Medical Examiner, and attached here too, are consistent with Dr. Scortibello's findings. So the some other doctor, pathological doctor, is saying that they found the same things, the same findings, no fight, nothing like that. So so now I'm gonna oh wait, I have more in this document. I almost forgot. Let's go here and here. All right, so this is more of the Commonwealth's argument as to why they believe the defendant, Karen Reed, should not get the Canton animal control records and Canton clerk's records. So here's our argument. Well, part of it. There's a lot more to these motions, and we'd be here forever. So I'm just sticking to like the relevant portions to the dog bites and the autopsy. So, all right. So the time frame requested by the defendant is far too overbroad, requesting records from 2015 to present with no showing as to why so expansive a set of records is even tangentially. Oh my God, I can't say that word right now. Relevant to the case. I normally can. My tongue's just died. The defendant further states that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head. Counsel avers that there is evidence of defensive wounds, a cluster of deep scratches, and puncture wounds to his upper arm and forearm. So they're saying, like, this is what the defendants are saying. But they're going to come back and combat that with an argument. So the defendant asked the court to take the inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan and the medical examiner's findings and sworn testimony, are consistent with dog bites for an animal, specifically a dog. So they're saying that it's not, everyone else is saying it's not a dog, it's not a dog, so you don't need these records. In support of these assertions, the defendant points to an affidavit from Dr. Frank Sheridan stating that the injuries are consistent with animal claw or scratch marks and a partial bite mark from an animal. Dr. Sheridan, in his affidavit, details the items he reviewed in coming to this stated opinion, but never indicates specifically what said opinion is factually based on. The court is subsequently left to infer that Dr. Sheridan, who looked at photographs, came to different opinion as the injuries origination and what those injuries actually consisted of than numerous medical professionals who, oh my God, this is the longest sentence, medical professionals whom all saw and viewed the body of Mr. O'Keefe, with Dr. Scortibello actually performing a thorough external and internal examination of Mr. O'Keefe's body and finding none of those injuries. So they're saying all these people were there, they saw him, it's not a dog bite. So you don't need to worry your little head about it. The victim, you should just take our word for it. The victim's medical records belie this characterization of his injuries. The medical records from Good Samaritan characterized the victim's injuries as right superior orbital ridge region, approximately 7 millimeters, laceration and surrounding soft tissue, contusion. So I think we already kind of got that. Dr. Scortibello testified before the grand jury at length regarding the victim's injuries. The doctor described Mr. O'Keefe's right arms as scratches by a blunt object. So then what caused that? It had to have... A car isn't a blunt object. So I don't know how he got those scratches from a car. But, all right. So the doctor noted that they appeared in a linear pattern. The doctor detailed that she observed no signs of an altercation or fight from her examination of Mr. O'Keefe. Lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. I'm sure it did contribute to some of the swelling as to why it was so bad. Sorry, what did I do with my water? Oh, it's right here. Okay. So, yeah, I'm sure some of the swelling was actually from the head injury. I think he was in a fight. Honestly, what I think. He was in a fight and it got out of hand. The dog stepped in because usually dogs want to protect their owners. And it wasn't a police trained dog, as we most likely learned from Melanie Little's show, because they don't use female dogs. And it was a female dog. So we can pretty much assume she wasn't police trained. And she probably started to get in on it after the fight erupted, because that's what dogs want to do, is get in there and protect. And they have that drive in them. It's innate. So that's what I think happened. And he may have even fallen when that happened and hit his head, and everybody at the party freaked out, and or whoever was in that room at the time, because I don't think everybody in that house knew, but everybody was escorted out quickly for purposes of getting rid of the body, being able to hide the body. This is my speculation, and I'm just kind of going off on what I feel from reading this stuff in this case. I think he got into a fight and something happened with the dog, jumping in and stepping in, and then he fell back and hit his head on something, which gave him that laceration and knocked him unconscious. And that is when everybody, or whoever was present at that moment, said, okay, party's over, time to go. And everybody went home. That's my opinion. That's what I think happened, but I wasn't there. So I kind of want to skip on over to this motion. This is a renewed motion. So the defense actually had a motion to compel discovery for all this evidence, including the dog bites and the Canton records and everything. And whatever happened, it got shut down or things happened. So now this is the renewed motion to compel. So they basically are just asking, I'm not going to read it all because it's just lists of things, but basically they're asking that the court ask the Commonwealth, or basically order the Commonwealth, to turn all of this stuff over, because at this point in time they still had not received any of these items on this list. So this was filed August 2023, and they still had not received a ton of evidence, including John O'Keefe's clothing. Excuse me. John O'Keefe's clothing. As you can see, he's got jeans, boxer shorts. They have debris from his sneakers. They have sample stains on his legs of his jeans. So they have all these samples that the Commonwealth disclosed. Like, look, we have a list of all of these things. This is what we have. And uh, the defense is like, okay, these are the ones we want. We want to do the samples of the gray long sleeve shirt. We want samples of the black debris from the gray shirt. We want samples of this and that. And then they're supposed to hand it over. Well, at this point, they still hadn't in August. And it still took a while, I think, for much of it is still, I believe, being fought. A lot of the discovery, a lot of the evidence was not being turned over, and it's really unfortunate. So, okay. The second part, the defendant requests the ability to inspect and independently test the actual items of John O'Keefe's clothing. So they actually want to test the clothing themselves independently. John O'Keefe's baseball hat, which is not listed in the evidence log, but was photographed as an item of evidence recovered by law enforcement from 34 Fairview Road on February 3rd. So they found his hat on February 3rd, apparently. Okay, so more searches and more finding things at the house way after the first initial search. So it's just odd. But yeah, and the defense still wanted to test all these things. I don't even know if they have yet been turned over, but some things have been rolled on. I'm not exactly sure everything because there's a bajillion motions. But yeah, isn't that interesting that they're just not turning over the clothes? They won't turn it over. Something else just to point out is the taillight pieces. They're not turning those over either. They've been wanting to test those and they cannot get their hands on them, as well as the Lexus infotainment and telematics, which would show where she was, when she was, if she reversed, if she did a 3-point turn, if she hit something. I'm sure it would say that. So they're looking for that, which they still haven't gotten yet, the defense. And then the certificate of unaliving, they never got that from the prosecutor, so they had to go and get it themselves. Just pointing those out because they're interesting facts, because they're just not turning things over. Doesn't really have to do with the topic, but that was interesting. All right, so reports regarding swabs taken in connection with John O'Keefe's clothing for submission to UC Davis Lab to determine whether animal DNA is present. This is why it's important that they don't have John O'Keefe's clothing. They want it because they want to check if there is any kind of dog DNA present, any kind of non-human DNA present. And that would for sure be a giveaway that something happened in the house and that he was definitely in the house. If he had DNA on him from Chloe, then we would know that he was for sure in the house. Okay, so anyways, they're also requesting that any clothing swab samples submitted to UC Davis Lab for animal DNA testing be run with canine markers such as the dog DNA file type will be preserved for later comparisons. They are looking specifically for dog DNA. Here, they're just arguing why the Commonwealth is constantly trying to impede, because basically the Commonwealth has objected to every single request that the defendant has made. So they're saying in here, like, why do you have to impede the defendant's access to the items of the clothes? Because, she has a right to test them as well. She has an absolute right to get her own independent investigators to test these items. And they're just not handing them over. And they're refusing to permit defense counsel access to these items. So that's an important factor. Taillight, they're asking to inspect. Here are item 6, reports regarding swabs taken in connection with John O'Keefe's clothing for submission to the UC Davis Lab to determine whether DNA from an animal is present. On July 17th, 2023, ADA Lally, so a Assistant District Attorney Adam Lally, emailed Defense Counsel stating that MSP, so Massachusetts State Police, has taken 2 samples from Mr. O'Keefe's outer clothing, specifically the right arm sleeve of John O'Keefe's long sleeve shirt, for submission to the Veterinary Forensic Genetics Laboratory at UC Davis for forensic testing to determine the presence of non-human DNA. So Lally emailed the defense saying that he sent this off to be tested, i.e. the presence of dog DNA. Okay, further, Mr. Lally explained that testing would be exhaustive and UC Davis will not allow outside individuals in the lab to observe casework. Attorney Little, I think her name's Elizabeth Little. She's another attorney that's on this case. She emailed ADA Lally requesting, for the defense, she's on the defense side, and she emailed Lally requesting any reports associated with the taking of the 2 swabs the Commonwealth intends to submit the UC Davis lab per the specific instructions, which were sent to the MSP lab by UC Davis forensic scientist and analyst Terry Kuhn, as seen in emails between the 2 labs, which were produced in recent discovery to the defense. In other words, although the defense has no objection to UC Davis testing the swabs to determine the presence of animal DNA, the defense wants to ensure that the MSP lab has properly followed all protocol outlined by UC Davis in obtaining the samples for submission, particularly because at least one of the criminalists currently working on this case recently failed certain competency tests immediately prior to analyzing evidence in this case. So there are apparently analysts in the lab that have failed their competency tests recently. So that's interesting. And immediately prior, I missed that part. Okay, so certain competency tests prior. All right, we'll get out of here. So it failed certain competency tests immediately prior to analyzing the evidence. So right before this case happened, right before they get the evidence from John O'Keefe's clothing and all that, right before that, one of their analysts in the lab failed their competency testing. So something to think about. On July 21st, 2023, Mr. Lally responded that he, quote, requested those reports you referenced associated with the taking of the 2 swabs and will forward them to you for your review, end quote. To date, the defense counsel has not received any of those reports. So that was July 21st, 2023. This was what I said, August. So yeah, they, a month later, they still had not received the samples that the district attorney said that they would hand over. Item 7, the defense is requesting that any clothing swab samples submitted to UC Davis lab for animal DNA testing be run with canine markers. Okay, so what does that mean? As set forth in email communications between the UC Davis lab and MSP lab, which were previously produced in discovery, UC Davis lab inquired as to whether the MSP lab wanted them to test the swabs taken from the right sleeve of Mr. O'Keefe's long sleeve shirt for 1, the presence of animal DNA, or 2, the presence of animal DNA and canine markers such that the dog DNA profile would be preserved for later comparison. On July 18th, 2023, Attorney Little emailed ADA Lally requesting that any clothing swab samples be run with canine markers such that the dog DNA file type be preserved for later comparison, per UC Davis analyst Terry Kuhn's May 18, 2023 email. So that's the way that, I guess that's just the type of testing that they want done on John O'Keefe's the swabs of his right arm. Right? It's his arm or clothing. It's his long sleeve shirt. Okay. Attorney Lawley's response on July 21st, 2023 completely ignored this request. Thus, the defense asks for confirmation that any samples submitted to the UC Davis lab be analyzed for both the presence of animal DNA and for canine markers to ensure the animal DNA profile would be preserved for comparative testing at a later date. So they're just trying to preserve the sample so that they can test it if they need to test it again in the future. So that's it for that document. These next ones should be not too bad. They're shorter. This is later on. When is it? Okay, May 23. This is earlier than the ones that we were just reading, but this is coming from. Well, here this is actually the order coming from the judge, but you'll see what it's about. So the defense was asking for the Canton animal control records, right? So this is the response from the judge about that. So good cause shown. It is hereby ordered, pursuant to Mass. R. Crim. P. 17A2, that the Norfolk Superior Criminal Clerk's Office issue a summons to the following agencies to deliver the described records to the Clerk of Court in advance of trial. So there's the address. We are seeking all records and or other information related to the licensure, ownership, quarantine, rehoming, and or any skin piercing incidents of any animal registered to Brian Albert and or the owners of 34 Fairview Road, Canton, Massachusetts, between 2015 and present. So they are seeking to find it. I believe the reason that they're going back to 2015 just for like an overview of the dog's life, to see if there have been any incidents in the past of this dog biting people. We are being told by the Alberts that no, there's no history of aggression or anything like that. But then if you look, there might be. And most recently, well, I'll get to that when I get to that. All right. So all records and or other information related to the licensure, same thing that it says here. Defense counsel shall have access to this information. No further disclosures may occur absent further order of the court. So she's saying all of this stuff is good. Don't do anything more than that, but give them everything that relates to what we just described up there. So if there's any incidents of dog biting someone or another dog or whatever. So that's that from the judge. Then I kind of want to skip over it. We're kind of skipping around in like different documents, but I'm looking specifically to show you documented proof in court documents, the allegations and the way that the stories are changing and things like that. I want you to see how it's playing out, and I hope that I'm not going all over the place in this one, but you'll see here. This is the memorandum of decision and order on defendant's motion for an order pursuant to the directed to Canton Animal Control and the Canton Clerk's Office. So this is the decision that came down from the judge after I was thinking at some point in between, I know that the Commonwealth had done like a order protection so that they could not get the records, but I think that they lost that one. I'm not sure. But here we'll see what the judge says here, Judge Canoni. The defendant, Karen Reed, is charged with murder in the second degree of violation of GL 2651 manslaughter. So originally it was manslaughter, and now it's second degree. um, M word because they upped the charges at some point in time. So, okay, so manslaughter while operating under the influence of alcohol in violation of GL whatever code and leaving the scene of personal injury and death in violation of this other code. So the charges arise from the unaliving of her boyfriend, Boston police officer John O'Keefe, who was found unresponsive and in the snow outside a residence in Canton on the morning of January 29th, 2022. The case is before the court on the defendant's motion for an order pursuant to directed to Canton Animal Control. So the court is saying, okay, so I have been directed to rule on this. And here's my findings. So after a hearing on May 3rd, 2022, and review of written arguments submitted, the defendant's motion is allowed. So they are allowing the defense the subpoena, which we read here was the subpoena for the Canton, whatchamacallit, the animal control, to get all records for Brian Albert or someone living at that house. So I'm not going to read the background because we already know the background on the story here. Was there more? Okay, here. So the Canton town clerk informed a defense investigator that a dog license issued for a 4-year-old German Shepherd associated with Albert's residence in 2019 and that the dog was rehomed to Vermont in May 2022. So very shortly after. So John O'Keefe, his life is ended on January 29th of 2022, and then 5 months later you get rid of your dog. 4 months later you get rid of your dog. Because January is already over. So yeah, you get rid of your dog shortly thereafter. A Canton animal control officer subsequently told the investigator that she wrote a quarantine order for the dog after a purported skin piercing incident in May 2022, and that Albert later rehomed the dog. Both the clerk's office and the Canton Animal Control refused to release the related records without a court order. Why? Like, why do people have to be so difficult? Like, just give it over. Ugh. Anyways, so yeah. The defendant now seeks from the clerk's office and animal control the production of records related to the licensure, ownership, quarantine, rehoming, and any other skin piercing incidents of any animals registered to Brian Albert and or the owner of his residence between 2015 and present. Defendant's motion, whatever. So that's pretty much it. I don't think I had any. Oh, this might be actually kind of interesting. Okay, here. Yeah, I guess we should listen or read the discussion here. All right, so under Mass R. Crim P 17A2, the court may issue a summons ordering a third party to produce books, papers, documents, and other objects prior to trial. The purpose of Rule 17A2 is to expedite the trial by providing a time and place before trial for the inspection of the subpoenaed materials. Coming from Commonwealth versus Dwyer. Quoting United States versus Nixon. In deciding a defendant's motion pursuant to Rule 17A2, the court must balance the defendant's right to mount a defense with the Commonwealth's right to prevent unnecessary delay of the trial and unwarranted harassment of witnesses and third parties. Again, Commonwealth versus Lamb. To succeed, the defendant must establish good cause by showing 1, that the documents are evidentiary and relevant, 2, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence. So they have to be relevant, and you can't just go out and get them on your own. Don't bother me. If you can go get this on your own and you're coming to me, I'm going to deny your request every time. If I was a judge. Anyways, I'd be a mean judge. No, I would love to be a judge. Anyways, number 3. So 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. So these are such mouthfuls. You could say this so much easier. So the party cannot, the information that you're seeking has to be something that you need to prepare for trial. And I don't know what the inspection may tend unreasonably to delay. Oh, just if production and inspection of it delays trial, then yeah, that's not good. And 4, that the application is made in good faith and is not intended as a general fishing expedition. So remember, in the Commonwealth's memo, they said this is just a fishing expedition to see what happened to Chloe, but it really isn't. It's quite relevant, in my opinion. All right, so Commonwealth versus Lampron, 441, Mass, all those numbers, quoting Nixon, U.S. at all that. Okay. Each of these requirements are met. Okay, so that's why she made her decision the way she did. All of these requirements have been met by the defendant. The ones that I just read up here. So first, the records sought are both evidentiary and relevant. This requirement is satisfied if the records have a rational tendency to prove or disprove an issue in the case and are likely to be admissible at trial. Commonwealth versus Jones. Quoting Lampron, the records at issue pertain to Albert's ownership of his dog, a reported attack by the dog, and the dog's subsequent rehoming. Such records would rationally tend to show that Albert's dog was prone to attacking people and thus offers some support for the defendant's theory that the dog attacked O'Keefe. The defendant's theory is supported by expert evidence that an animal caused some of the injuries to O'Keefe's arm. The request for records is not temporally overboard because the time period requested is specifically tailored to begin in 2015 when the dog was a puppy. So they are trying to go back to when the dog was still just a puppy. I can't get to it. Sorry. So yeah, they want records of the dog's whole life, basically. And so, because in the other request, or in the motion to deny it from the Commonwealth, they said that it was too long, too much time that they were asking for, 2015 to current, but that's when the dog was still a young pup and learning its ways around the world. All right. So therefore, the records are relevant to the defendant's third-party culprit defense and have evidentiary value. So a third-party culprit is like a strategy that you're trying to prove some other third party did this and not me. It doesn't matter who that third party is. It could be an invisible third party that you don't know, but if you're trying to like tie it onto another person, that's your strategy. It's just a strategic move. So second is, it is undisputed that the records are not otherwise procurable reasonably before trial. This requirement imposes on the moving party an affirmative obligation to show that no other source likely exists for the desired records. That's from Dwyer. The defendant has shown that the records at issue are in the possession of the town clerk and animal control offices. Neither office will release the records without a court order. Therefore, the defendant has no other way to procure the records before trial. So see there that the fact that they were denied access to the records actually benefited them because they couldn't get it otherwise. Third, it is undisputed that if the defendant does not obtain the records before trial, she would be unable to properly prepare her defense and the trial likely would be unreasonably delayed. This requirement is, quote, is designed to limit use of Rule 17A2 to instances where the absence of pretrial production would tend unreasonably to delay the trial. It is reasonable to expect that the records contain further details regarding the reported attack by Albert's dog and the dog's rehoming, likely including the identity of witnesses with knowledge of these incidents and the dog's current whereabouts. Still, we don't know. Like, just because they said that the dog was rehomed doesn't necessarily mean that it was. So we just have to take their word for it. Again, that's basically all this case has been. Oh, just take our word for it. Oh, yeah, we found taillight there. Yeah, sure, take our word for it. To properly prepare her defense, the defendant may choose to interview those witnesses. Furthermore, upon locating the dog, the defendant intends to pursue a comparative DNA analysis of samples from the dog and O'Keefe's wounds. So, bam, there you go. That's why the dog is missing, because they want a DNA analysis. And remember, this is done. When did she sign this? In May. Judge Canoni signed it in May of 2023, but this is May 19th. So, and that's about when the dog went missing, is what I'm saying. Like, that's the same month, same timing. Isn't that strange? I think the dog is dead. If you want my honest opinion, I think they killed it, buried it, but I don't know. And I think they just didn't want that DNA anywhere near them anymore. But it's not going to help, because you can't fix it now. You guys are in way too deep. All right. Where was I? Furthermore, upon locating the dog, the defendant intends to pursue a comparative DNA analysis of the wounds. Without pre-trial access to the records, the defendant's ability to prepare her defense would be hampered. Additionally, if the records are not produced, the trial will be unreasonably delayed. Lastly, the defendant has met the good faith requirement of Rule 17. This requirement serves as a reminder that 17A sorry, I don't know what is going on with my throat. 17A2 is not a discovery tool. The records at issue are known to exist and to be in the possession of the town clerk and animal control offices. Therefore, the defendant's request for a summons is allowed. Oh, bam. So there you go. She's allowing all of it because it's all relevant and it meets the 4 prongs that she established earlier. So here is the order for the foregoing reasons. The defendant's motion for an order pursuant to the Mass R Crim P directed to Canton Animal Control and the Canton Clerk's office is allowed. So they did eventually get the animal records, I believe. And we really don't know much more other than the dog was rehomed somewhere to Vermont. That's what they tell us anyways. So, I don't know. What do you guys think about that? Where do you think Chloe is? Do you think Chloe's dead? Do you think she is on a farm somewhere? Big old open farm where she can run and chase rabbits and do whatever she wants? Or what? I don't know. They say she was rehomed to Vermont in 2022. May of 2022. And it's the same time period as Judge Canoni, May 19th. Oh, I'm sorry. It's a year later. Oh, gosh. It's been a year. So they take... wow. I'm slow today. So it took a year for them trying to get the records because the Commonwealth kept denying, opposing it. So that's interesting. Okay, so it took a year for them to actually get the records. They say she was rehomed 4 months after the incident where John O'Keefe was unalived at 34 Fairview. But it was which I think is really strange. And then they shortly after that they sold their home and moved away. So, or not away, but moved out of their childhood home that had been in the house for generations. Anyways, that doesn't make sense to me. If that makes sense to you, tell me why in the description below. It's all confusing to me. I think I mean, seriously, I already thought that, you know what, I'm not going to give my opinion. I'm just going to say this. This case has been so shocking and so wild, and just the things that the big cojones that the establishments, the authorities think that they have. It's just amazing to see that in action. And I'm sure they didn't realize that they were going to be under a microscope by most of the nation. And that's what happens. That's why these police investigations need to be on the up and up always, every time. You can't fib information. You can't lie in your affidavits. You can't be omitting the exculpatory evidence when you know that Karen didn't do it. And it's just, it infuriates me. I started this channel because cases like these make me so mad inside. Like, I hate injustices. And I love learning about it. I love explaining it, talking about it. But it's so wild to me that we're in this day and age and this is still happening. People are being railroaded and framed by police. So it seems. Next episode, I kind of have a special little thing planned for us. So I kind of go through exculpatory evidence. So I'm going to take it piece by piece and kind of break it down as to exculpatory evidence and backing it up with court documents. So you'll see what I mean when we get to episode 10, which is going to be the exculpatory evidence. And then after that, I'm not sure where we're going to go from there. I think you may or may not already know that there's a federal investigation happening right now because of this trial. So I was going to get into all of the Canton 9 and the Turtle Boy stuff. But now there's the feds that are coming in on the Karen Reed case. So I'm kind of not sure which way I'm going to go. If you guys have a preference or really want to know something specific about this case, please let me know. I would love to hear your feedback and opinion, and then I can, make my episodes accordingly so that we're all happy here and enjoying the videos. I enjoy doing them. I hope you enjoy watching, and I hope that you will join me next time, and take care. Bye.